What types of evidence are most useful in a discrimination case in Florida?
Absolutely. And I can give a quick example of one that I thought was very fascinating. I had the pleasure once of representing a woman who was to be a single mother, pregnant, working in a restaurant, and the restaurateurs were engaged in a group that regularly encouraged restaurant owners to kind of be like secret shoppers at each other's restaurants. Like they would cross-pollinate and go and look at a similar restaurant that's owned by a different group and give each other constructive criticism. An out-of-town owner visiting a local restaurant in the Daytona area saw this pregnant waitress pass by and suggested that they had a pregnant waitress who slipped and fell and had a miscarriage, and that it was a nightmare and they should probably remove her from their payroll for fear of a potential claim against them. And a coworker of hers overheard the conversation and told her about it. She explained that to me, and I said, does she still work there? I'm curious, do you think she'll actually bite the hand that feeds her? And understandably, my client was not entirely sure how supportive that employee would be when push came to shove. But amazingly, what she did have, and again, this is rare, but it was fascinating to me, I asked if there were anything else that she was aware of that could verify that indeed her pregnancy was the cause of her termination. And she handed me a Medicaid application that was relatively unfamiliar to me, but I quickly understood how the process works. And she had prudently gone to apply for Medicaid to be able to provide care and treatment for her childbirth and immediate subsequent care. And part of what the government does is ask about last employment and how, if at all, that employment was terminated, whether it was voluntary or involuntary. She reported to the government, I was involuntarily terminated. The government sent the form to the business owner and asked the business owner to confirm, was the termination voluntary or involuntary? And he responded that it was involuntary. And then there was a box below that asked, please describe the reason or reasons for termination. And the employer, being very honest but candidly ignorant about the law, signed in good faith under penalty of perjury his name under the box, which had one word in it: pregnancy. That's the kind of thing that lawyers dream about and we almost never see, but it can and does happen. And that was one that literally took one quick phone call, a repentant business owner who asked for a little bit of time to do some research and understand if indeed what I was telling him was true, and a callback and a quick negotiation that resulted in a very favorable result for my client. And everyone walked away with a handshake, and he learned a valuable lesson about one thing that he was unaware was illegal to do in the workplace. And that was a satisfying and interesting one. Again, rare, but sometimes there are those unbelievable things or internal memos that discuss behind the scenes what's happening when the employee's told something else is happening. So anything specifically in writing denoting discriminatory intent is by far the gold standard. Unfortunately, it's rarer than more common, but those things really can and do exist.
For more information, an initial consultation is your next best step. Contact attorney Matthew Romanik at Working for Workers by visiting our website at www.workingforworkers.law.